Good morning, everyone. Thanks for joining us. I'm just going to wait a couple seconds here while people start filing in. Hope everyone is having a good day so far. Welcome to our webinar on Employee Injury Claims 101. My name is Cassie Hopkins, and I help run the webinars here at Hausman Group. Thank you so much for joining us live. We really appreciate it. I'm just going to go over a couple of things before Jason gets started here, and then we have a lot to cover. So if you have any questions, feel free to type them you can either type it into the question feature on chat, or you can just chat directly with us as well. We can do both. So if you have a question at any point in time, you can just throw it in there and we'll get around to answering it during the Q&A session. This webinar is also recorded, which means that you can come back to it at any time if you need to leave and you want to return to where you left off, or if you'd like to share it with someone. You can do all of those things when you receive an email, and it will give you a copy of the presentation slides as well as a link to that recording. Without further ado, I'm going to introduce our speaker today, Jason Hiller. Jason has been on our team now since 2022 as a claims resolution strategist specializing in workers' compensation. Before joining Hausman Group, he was the director of safety and compliance at a multi-state temporary staffing and recruiting firm. His 15 plus years of experience in work comp and return to work strategies give him a knack for walking that tightrope between protecting the organization and doing what's right, while also treating employees with respect and empathy. Work comp has always been one of Jason's favorite focus areas, and he's excited to bring his experience and knowledge to us today. Thank you so much, Jason, for joining us. Oh, you're muted.
There we go. You'd think after 5 years of pandemic, we'd learn how to unmute our Zooms, but we still have issues every now and then. Good morning, everybody. Excited to be here talking about workers' compensation with you all today. This is our Work Comp 101 presentation. Our agenda for today will be to talk a little bit about employee injury claims overall, how to initiate our claims process, some of the milestones as you're working through the claims process, the importance of documentation and communication, and then a little bit of HR and employer perspective as it pertains to workers' compensation. I will preface this presentation that the bulk of my experience has been in Wisconsin, and that is the tilt of this presentation is Wisconsin work comp. Every state has its own laws and rules, so if you have any outside of Wisconsin exposure and you have questions about those different state laws, please follow up with me offline.
Hey, Jason, sorry to interrupt. I think your screen is just showing the back end of the PowerPoint and isn't showing the presentation view. Just wanted to give you a heads up.
Oh, it's weird. I'm going to stop sharing and try again because it's definitely showing up on my screen. Is this better? We're on the agenda slide now.
Yes, we are good to go.
Okay, thank you. Thanks for letting me know. All right, so introduction to employee injury claims. The first thing that we should cover is why does workers' compensation exist? And I like to say, kind of the reason why all laws in the employment space exist is probably because there was some employers that weren't doing the right thing for their employees when work injuries happened. And so workers' compensation was created as a no-fault system to protect employees when injuries happen, as well as to protect employers. And the way that it protects you as an employer is that workers' comp is an exclusive remedy when a work injury occurs, which means that employees cannot sue you, and take action in tort court when there is some sort of negligence asserted by the employer. Prior to workers' compensation, the only way that an employee could get kind of compensated or get their medical bills paid was to sue them in civil court, which, as you probably hear in the property and auto claims world, can result in some nuclear verdicts and is way more costly. So states started kind of implementing their own programs to make sure that employees got taken care of when their injuries occurred without bankrupting the employer. So some of the benefits that are associated with workers' compensation, when you're talking about insurance, the concept of indemnification comes into play, and the definition of indemnification is to make somebody whole. So our goal here is to make the employee whole once a work injury occurs, and that comes in the form of medical payments being the primary benefit. So any doctor bills that are incurred as a result of their medical treatment will be paid for a compensable claim. Also have indemnity or lost time benefits. So this would be compensating them for any lost wages resulting from their work injury. Each state typically has what's called a waiting period, and this is a period of time that has to pass before lost time wages kick in. In Wisconsin, our waiting period is 3 days, so a person would need to miss more than 3 days of work before any lost time benefits would kick in. And once they do kick in, the insurance carrier would pay the employee 2/3 of their average weekly wage over the past 52 weeks prior to their injury. The reason that it is paid at 2/3 and not the full average is because these benefits are not taxed, whereas payroll is taxed. So they're earning about the same as their average weekly wage over the past year. Indemnity benefits come in the form of temporary total or temporary partial disability. Temporary total is when the doctor says that they cannot work at all in any capacity, they're totally off work. That would be temporary total disability. And then temporary partial means that they have some sort of restriction. So they were able to come back to work with either some physical restrictions, no lifting over 5 pounds, something like that, or they might have a time-based restriction where they can't work more than 4 hours a day or something of that. In that case, the carrier will take the wages they do earn, compare them to that average weekly wage, and pay the difference in between. For some of the more severe cases, they also are permanency or permanent partial disability benefits, um, as well as permanent total disability benefits. Those are all kind of structured in Wisconsin as far as the payment levels. Typically, it's a number of weeks of their average weekly wage. And there are some situations where there are permanency benefits built into the statute. So, for example, if you have a meniscus repair in your knee, there's a basic level, a statutory minimum level of benefits that would be paid towards the permanency. And then loss of earning capacity, which is when, maybe the person was injured such that they're not able to, secure employment and earn as much as they would have prior to the injury. In some of the even more severe cases, we're looking at disfigurement benefits. We see these with maybe some serious burns, or I like to give the hand model example. If you get a nasty scar on your hand and your job is that of a hand model, it might prevent you from earning as much as you would have before. So those are disfigurement benefits. And then death benefits. If somebody unfortunately passes away from a work injury, there are benefits available to cover funeral costs, as well as loss of consortium to the dependent spouse or dependent children of the deceased. So those are not as common. Fortunately, people aren't dying all the time from work injuries, but it does happen. And we want to make sure that the people that depended on the employee are taken care of in that situation. Like I said before, every state has their own workers' compensation plan. Jurisdiction can get a little bit tricky if you're a multi-state employer or have employees traveling in between different states. Each state has different laws. Wisconsin was the first workers' comp plan that held up to Supreme Court scrutiny. So we take a little bit of pride for that here in Wisconsin. If you have questions, like I said, about jurisdictional issues, let me know, contact myself or your agent, and we can talk through the specific circumstances. If your business is in the shipping or oversea kind of travel or work, there are also federal plans that cover longshoremen, offshore drilling, and military bases. And I always do like to point out that your standard out of the box workers' compensation policy does not cover international exposure. So if you have employees that are traveling abroad to other countries, you're going to want to talk about that with your agent and make sure that you have an endorsement to cover international exposure. Next, we're going to take kind of a look at the cost of employee injuries. As a business, if you're in construction, manufacturing, you're developing or delivering a product. Um, First you're going to look at your lost or damaged product as a result of that injury. Certainly decreased productivity from your staff. When an injury happens, you're with your coworkers probably more than you're with your family in a lot of cases. And so it's definitely going to be something that, stops production. People are going to be wondering what's going on and really kind of decrease the productivity at the moment. Business reputation is a potential cost. Employees want to work for safe employers. So if you start having a high frequency of injuries, it's going to get out into your community and you might not be a desirable workplace in that situation. And then certainly employee morale can be impacted. If one of your close coworkers gets injured, might make you a little bit sadder to come to work every day if they're not around for a while, things like that. When we get to the actual dollar costs of workers' compensation, the way that workers' comp is kind of charged is the most common anyways, is a guaranteed cost policy. This is where your premium is based on your industry class code and your payrolls. So typically it's a base rate of premium for every $100 in payroll that you generate based on your class codes. And then workers' comp in Wisconsin and in most states is experience rated. So it's kind of like car insurance, where the more accidents you have, the higher your rates tend to go. And conversely, the lower, if you have great experience and very few claims, your rates can go down. This is a rate that is calculated on an annual basis. If you're in Wisconsin only, it's calculated by the Wisconsin Compensation Rating Bureau, or WCRB. If you have multi-state exposure or are not in Wisconsin, you're rated by, it's called NCCI. And they're going to look at the first three of the last four policies. So it doesn't look at the current policy, but the three policies prior to that. And the reason that they look not at the current policy is because typically claims will develop over that year, and you want to get the claim closed before you're actually charged rate based on that claim. So because workers' compensation is typically a required coverage for employers, we try to shop in the free market and find a carrier that's willing to cover you. If that's not the case, or you're an undesirable risk for a normal carrier, most states have what's called an assigned risk pool, and this is a pool of carriers that are going to cover those employers that other carriers won't voluntarily cover, and each carrier kind of cycles through as a pool carrier on a rotating basis. So even if you have bad experience, there will be a carrier that will cover you. And then there's also some more dynamic programs in alternate risk financing, things like self-insurance, retroactive plans, and insurance captives. If this is something you're interested in learning more about, we do have a session at our upcoming seminar in September, which Cassie will talk about at the end, or just reach out to your agent and ask some questions about alternate risk financing for work comp. There are some claims in the workers' compensation realm that are not covered by your workers' compensation policy, and I just like to make sure that employers know about these. The first one is what's called an unreasonable refusal to rehire claim, and this happens when an employee believes that the employer terminated them or did not bring them back to work after their work injury just because of the injury. And if this is found to be the case by the court system, the Department of Workforce Development, they can assess up to 1 year of wages for that injured worker. And that is, not, again, not covered by your work comp policy, so you'd be paying out of pocket. The second one is what's called a safety violation. So this basically asserts that the employer was aware of some sort of safety violation that was not remedied, which led to the injury. And if this claim is kind of approved by the division, this could result in a 15% increase in the indemnity benefits on the claim, up to $15,000 total. The biggest defense that I like to let people know about on this are training sign-offs. So, if somebody gets injured on a machine, and they try to assert a safety violation, the number one kind of argument that they have is they were never trained how to properly use that machine. If you're doing proper training and you're having people sign off on that, that is a really strong defense against the safety violation. The nice thing about safety violation is that it can go both ways. So the employer actually has a defense if the employee is knowingly violating a safety rule. We'll talk about that in a little bit in the employer defenses section. So once a claim happens, how do we initiate the claims process? The first step, and this is true of almost any of your insurance policies, whether it be your homeowners, your automobile policy, your first duty under your policy is to make sure that further injury or damage is prevented. So if somebody is injured by a machine, make sure that machine is turned off, it's locked out, that nobody else can get injured from whatever the cause of loss was. And certainly if emergency treatment is necessary, make sure the employee gets taken care of urgently as appropriate. I also like to make sure everybody understands that you don't need to delay reporting the injury to your carrier based on a lack of information. Get them what you do know and get the claims process going, just to kind of expedite the processing. The sooner you can let the carrier know, the better for workers' compensation, especially. Some of the key details that they will need to get a claim set up include the employee's name, their social security number, date of birth, the date the injury happened, some sort of description about what happened and the body part that was injured. And if possible, if you know where the person has gone for treatment, this just allows the adjuster to get in touch with the medical provider and get billing stuff set up and make sure that they're providing the documentation that we need to move the claim forward. But again, if you're missing any of those pieces, don't delay the reporting. Just send in what you know, and they'll follow up with you after the fact to get any additional information that they may need. So the next step would be, again, to notify the carrier. If you're not sure how to report to your carrier, contact your agent or me if you're a Houseman client, and we can definitely help you get that claim reported. Most carriers have an online portal or phone number to call in claims. Fax and email tends to be kind of the most prominent. You'll fill out kind of the first report of injury, which I'll show you here in a little bit, get that over by email to the carrier, and that kind of starts the claims process rolling. Once that's taken care of, you're going to want to make sure that you're promptly completing your incident investigation to find out what happened and how we're going to prevent it in the future. Talk more about that here in just a second as well. So on the carrier side of work comp, I just like to kind of share some of the roles that people are playing you might hear throughout the claims process. First and most prominently, you'll probably hear from an adjuster. This is the person at the insurance company who is responsible for medical and financial management of the claim. When we're looking at the financials, there's kind of two buckets, the paid bucket and the reserved bucket. So once a claim is established, the adjuster will assign a reserve, which is kind of what they anticipate paying on the claim. So we'll just use a nice round number of $10,000 posted on the claim in reserves right when the claim starts. As the bills start trickling in, they'll pay those bills. That money will move from the reserve bucket over to the paid bucket. And the sum of both of those is what's called the total incurred value of the claim, so paid plus reserves. And then many carriers also have a line on like a loss run called expense. An expense is the carrier's cost of managing the claim. It's not necessarily a direct cost of the claim. So that's paying for things like independent medical evaluations, nurse case managers, things like that that are assisting in the claim management process. The nice thing about the expense bucket is that the expense column does not feed into your experience mod. Only the medical indemnity benefits would feed into your experience mod. Many carriers also tier their adjusting structure. So some of the more basic minor claims will go into what's called maybe a medical only unit. These are kind of lower, more junior adjusters typically that are looking at claims with no lost time. And some even have, open and close medical only claims where they just close them out right away with no reserves and just process the bills as they come in. As the claim severity escalates, there tends to be other kind of departments within the adjusting structure. So if there is lost time on a claim, it will probably be bumped up to an indemnity adjuster. And then most carriers have a catastrophic unit that handle kind of the worst of the worst claims. Um, and those tend to be more senior experienced adjusters as well. Another player you might hear about in the claims process is a nurse case manager. These are registered nurses that either assist telephonically or in person, kind of helping the adjuster obtain records, communicating with the employee and the provider. Um, and they can really play a valuable role with the injured worker in making sure they understand kind of what's going on with their treatment, making sure if they need help getting appointments set up, they can help with that, getting records back and forth, things like that. So um, really a big fan of nurse case managers when they are appropriate. Another player would or step in the process would be an independent medical evaluation or a medical record review. These are kind of tools in the adjuster's toolbox if we think that there's some doubt as to the cause of the employee's injury or kind of the nature and extent. Like, were they really injured as bad as it looks from a work injury, or did they maybe have an underlying personal health condition? Also, I see them used quite a bit if treatment is going on beyond, where we would expect a claim to be. So maybe if they've been treating for more than 6 months and for what seemed to be a fairly minor injury, we might use an IME to get an opinion from a third-party doctor if that treatment that's ongoing is reasonable and necessary. These are impartial third parties, and they're typically considered the insurance company's quote unquote second opinion. The employee also has the option of obtaining a second opinion if they don't believe that the doctor that they're seeing is doing what they need to be doing. And then as we look at getting the injured worker back to work, you might hear about a vocational expert being involved. These experts evaluate injured workers' ability to secure gainful employment in the future with or without retraining. They assist in identifying retraining resources as necessary and assist in job placement activities if no position is available at the employer. So this is where we're looking at that kind of loss of earning capacity benefit, helping the person get back to gainful employment and making the level of income that they were making when they were injured. A lot of the vocational companies as well offer third-party light duty partnerships. So if you ever have an employee that has restrictions that you're not able to accommodate, rather than just paying them to sit at home and not work, you could explore with your adjuster if they have a light duty partnership where the vocational company would find an offsite employer, typically a nonprofit, where the employee would go work for them within their restrictions. That party would supervise, and then you would pay them the wages that they would be earning as if they were working in your office or in your facility. Really big fan of getting people back to work for many, many reasons. If you're ever interested in learning more about your particular carrier or their light duty partnerships, please let me or your agent know, and we'll be happy to kind of talk through those specifics with you. All right, so now we know kind of who the players are in the claims process. Now I'd like to talk about the milestones or the major stages that we're looking for as we progress through the claims process. So the first step obviously is initial treatment. Employee gets injured, they go to the doctor. The doctor starts the treatment process. Once this happens, the carrier will start their compensability investigation to determine if this was indeed a work injury that is compensable under the workers' comp laws. This is where all of your information and documentation can really help them fill in the blanks and complete their investigation. So after that initial treatment, we are really looking for some sort of return to work, whether that be in a restricted or light duty capacity or full duty. Obviously, full duty is the goal to get them back doing their normal everyday job. As the claim progresses, we'd be looking for what's called end of healing or discharge from care. So once they're at full duty, they might continue to have physical therapy or other appointments. The doctors basically haven't determined they're as good as they're going to get. Once the doctor says you're as good as you're going to get, that's called end of healing or discharge from care. This is the time when they would assess any permanency related to the injury and or vocational retraining necessities, as well as if there are any loss of earning capacity issues or if the person is Medicare eligible. This is something that the carrier has to take into account as well because Medicare certainly does not want to be paying for work injuries. So next we will take a look at what the requirements are for a compensable workers' compensation claim. The first one is that the injured party must be a W-2 employee of the insured employer at the time of injury. So they have to be your employee. Things to keep in mind if you work with independent consultants or subcontractors, making sure they have adequate coverage for workers' comp for their employees is super important. You can accomplish this by requesting a certificate of insurance because in the subcontractor situation, if the sub does not have adequate coverage, they may roll up to the general contractor and their coverage to make sure that the employee gets taken care of. The next requirement for a compensable claim is that, and this gets into a little bit of legalese, so bear with me here for just a moment, but the injury must be by accident or occupational exposure. Accident is an important term. Things that are done maliciously or intentionally are not typically covered by workers' compensation, and that the accident has to arise out of and in the course of employment. So when we look at the term arising out of, this speaks to the cause of the injury and the kind of concept around risk. And there's kind of three buckets that fall into this arising out of category. The first one would be increased risk. So by being at work, that person was at a greater risk for injury than the general public. Actual risk. This is the easy one to figure out that, they were working on a saw. A saw is dangerous. There was an actual risk. And then positional risk. And this is another grayer area where you're looking at if the injury would not have occurred but for their employment. Positional risk comes into play a lot with kind of, if you've heard of the term creature comfort doctrine, where I've seen an injury where somebody was opening a can of soup in the lunchroom and licked the lid and sliced their tongue open. Well, they wouldn't have been in that break room, having that can of soup, but for the fact that they were at work, and it ended up being a compensable claim, things like that. I saw another one where an administrative employee was working on a fairly large campus, and on their break time, they went for a walk out in the grounds around a lake, tripped on a rock, fell and broke their ankle. They weren't really doing anything associated with their actual job, but they wouldn't have been in that location, walking around that pond had they not been at work for the day, things like that. So that's where positional risk comes into play. The in the course of speaks to the time, place, and circumstance of the injury. So this is kind of, where were they, and were they supposed to be there? Was there a work-related reason why they were where they were at when the injury occurred? Things to consider in this realm are inside versus outside employees. So inside employee would be like me, I come to the same office every day. My travel is the same to get to and from work. Outside employees looking more at employees who travel a lot for work, whether they be in like a sales role where they're bouncing around from client to client, or a construction superintendent that's going from job site to job site. They have a little bit more exposure in their travel, so they're considered an outside employee, and a lot of that travel time would be potentially compensable under workers' compensation. Whereas if I'm just driving to work for the day and I get in a car accident, that's not work. That's not considered work related. Personal comfort, again, talking about, slip and fall in the bathroom, certainly not related to the job itself, but they were in the course of employment when it happened. Any sort of travel for work, whether it be to a seminar, to another offsite location, I typically work in the Houseman Group Madison office. If tomorrow I'm going to work out of the Milwaukee office, that's a deviation from my typical traveling. And so that, if I get an accident driving to Milwaukee, that could be considered compensable under workers' comp. And one of the biggest defenses in this in the course of bucket is what's called deviation. So means that they were doing something totally outside of the scope of their employment. A couple examples of deviation would be I had a claim once where guy was working in a restaurant and a buddy of his pulled up in the parking lot to drop off a shirt or something that he needed. He ran out to the parking lot. The person had a dog in the car. The dog bit the guy as he was reaching for his shirt. Tried to file a workers' compensation claim on that because it happened while he was at work. However, running out to the parking lot to grab a t-shirt has nothing to do with his job. The employer did not ask him to do that. And in fact, he probably should have been reprimanded for stepping away from his workstation. So that claim was denied as a deviation. Another example, if you have a traveling outside employee that's, driving around for work, they stop at McDonald's to grab lunch or something, going to McDonald's was not related to the job. It wasn't something that he was asked to do by the employer. That's considered a deviation from the course of employment. All right, moving on. The next requirement for a compensable claim is that they must sustain a quantifiable loss as a result of the work incident. So there has to be a loss. Employee has to be in a worse situation than they were before it happened, whether that be medical bills, lost wages, or loss of consortium that I mentioned before, which means their family has lost, somebody that was a support system for them. And probably one of the biggest questions I get around compensability of claims is around pre-existing conditions. And, somebody comes into the job with a degenerative back condition and that something at work happens and suddenly it gets worse. The concept that we're looking for in that situation is was this an aggravation of their pre-existing condition or an exacerbation? So basically, is it just typically is it like a flare up of that condition where it's going to just, treat one or two times and then it's better or back to where it was? Or did the work incident exacerbate it beyond its natural progression, which is a more serious situation? We talk about take them as you bought them concept in workers' compensation. So when you hire an employee, you're hiring them as they are. And the only real way to find out about any of these underlying conditions, because most people aren't going to just show up in an interview and tell you their personal health history, nor should they, is to implement strong pre-employment screening processes to make sure that you're really hiring the best candidates for the positions that you have. One of the key components to a successful pre-employment screening program is adequate and thorough job descriptions to really get to the bottom of what the essential job duties are and the physical requirements to do those job duties. Talk about our seminar again. We do have a whole session at our upcoming seminar in September about pre-employment screening, where we will be talking with a occupational therapist and a employment attorney about, those kinds of programs, how they're beneficial and what pitfalls to avoid. All right, so now we know kind of what we need for a compensable claim, and now we'll talk a little bit about the defenses and kind of what might help us deny a claim if it's appropriate. The first one, as I mentioned earlier on the employee side, is the safety violation for the employer. This means that the employee violated a known and enforced safety policy. Known and enforced are two key words in this statute. So the employee has to know about the rule. Typically, this would be in the form of some sort of training program or an employee handbook. And you have to be able to prove that they knew about it. So this is why you always want to have a sign off for any sort of training or employee handbook that you have. And certainly doing periodic re-signings of these types of key legal documents is super important as well. Because if you try to assert that somebody started working for you 25 years ago, read their employee handbook, it might be a little bit difficult to say that they should have remembered what all the policies were for 25 years. And then enforced. So the biggest kind of loophole in the safety of this one is that the employee could say, well, yeah, everybody else does it this way too. And so, it's a rule, but nobody actually follows the rule, and there's never any discipline for people that don't follow. So if you have a policy, know what the policy is and make sure you're applying it uniformly and treating everybody the same when it comes to enforcement. If we're able to prove a safety violation on the employee's end, this could result in a reduction of indemnity benefits of 15% up to a maximum statutory total of $15,000. How I see that typically play out is maybe a lockout tagout type of injury where the employee has had a prior warning about lockout tagout, and then they do the same thing again after the warning. There was a policy, they knew about the policy, they'd violated it before and had been reprimanded, and then they did it again. So there's a fairly decent burden of proof on the employer side to prove the known and enforced concept around this safety violation, but I have seen it successfully applied 2 or 3 times in the last couple of years, so it is something that the state is willing to implement as appropriate. Another thing I get questions about quite a bit are drug and alcohol use. A lot of companies have a post-accident drug screening program. However, in order to actually impact the workers' comp benefits, there's a few kind of arms that have to be met. The first, again, is a known and enforced drug and alcohol policy, having the written policy, having people sign off on it, making sure they know about it. You also have to, and this is where we run into problems sometimes in the evidence side, is there has to be a direct correlation to the injury that is provable. So you have to be able to prove to a judge that had the only reason the injury occurred was because the person was under the influence of drugs or alcohol. Having a positive post-accident drug test is not enough to prove that direct correlation. Um, Alcohol is a little bit easier to prove a correlation. We have a standard in Wisconsin of, what's considered legally intoxicated or impaired. However, other drugs are not as clear cut. Marijuana, for example, somebody may have marijuana in their system, but it doesn't mean that they were, under the influence at the time the injury happened, or, and more importantly, that the marijuana was the direct cause of the injury. It just happened to be in their system. So it's a hard burden to prove, but if you are successful in proving it, it does result in a full forfeiture of the indemnity or death benefits. However, medical bills still are covered in that situation. Next, we're going to talk a little bit about documentation and communication. As we mentioned earlier, the first step in reporting the claim is typically completing what's called a first report of injury. If your carrier has an online portal that you're using, the fields should be remarkably similar. Again, every state has a different first report of injury, but they're all relatively the same. And if you're used to using Wisconsin and you have a Colorado claim, it's not the end of the world if you send in the Wisconsin form for a Colorado claim. The carrier will just get it transferred over to the right state form. So looking at the first report of injury, the top part is kind of the employee and employer demographic information. Key pieces, as I mentioned before, their name, social, birth date. If for security purposes, you're not comfortable putting a birth date or social security number, or you want to mask, some of the numbers in the social, go ahead and do that. Like I said, the adjuster will just follow up with you because they will need it eventually for, reporting purposes. They have to tie it to the employee personal identifiable information. In the employer section, the important pieces are your employer name. If you have a legal entity that differs from kind of the common business name, it's ideal if you can put that what the legal entity is that is the named insured on your work comp policy, just for clarity purposes. However, they're going to call and ask questions if they're not sure. Putting your mailing address is important. The FEIN can be helpful. And then if you know the name of your work comp carrier, I encourage you to put it in. And if you have your policy number, it's super helpful sometimes to put the policy number in that name of workers' comp field. And most employers don't have a third-party administrator unless they're self-insured or, maybe are a really large employer that contracts with somebody else to help manage their workers' comp. But again, just get as much of the details as you know on the form, leave the fields blank that you don't know, and get it sent in to the carrier to get the ball rolling. The middle section is all about wage information. This is not typically required unless there is anticipated lost time from work. So if you're going to skip a section of this form just to get the claim submitted, this wage section is probably the best one to skip. Certainly something the adjuster can collect from you later on. And if you know that it's just a minor, laceration or something where they just had to get stitches and there's not going to be any lost time, certainly okay to leave that blank as well. And then the bottom is the actual details about the injury, the date, time of the injury, when they last worked, have they returned to work or not? Did it cause death? Were they hospitalized? This is a good place to put, the medical provider if you know it in that middle section. And then it's asking for the details about what happened. So you can kind of see there are 3 different questions here that are all somewhat similar but different in what they're actually asking. So the first one is to describe the activity that the employee was doing when they were injured. The second one is what happened to cause the injury. And the third is what was the injury. So what were they doing, what caused it, and what's the actual injury? So the kind of 3 different answers that kind of lead to the same overall description of the accident. And once we get that filled out, we're going to move on to your prompt incident investigation. Definitely recommend completing some level of investigation for any type of employee injury. The purpose of this investigation is to gather relevant details, either for the work comp claim or possibly for OSHA. Certainly to prevent future injuries by figuring out what happened, we can make sure that it doesn't happen again. And to identify possible negligent third parties. If there are other negligent third parties involved, the work comp carrier can pursue what's called subrogation or recovery. So for example, in a motor vehicle accident, if your employee is rear-ended by another party, that third party is typically deemed to be negligent, and work comp carrier can pursue that driver's auto insurance to recover the money that they're paying out on the claim, which then positively affects your experience because they're getting their money back. This also, we see this used in Wisconsin in the wintertime. If you have a snow removal company that isn't fulfilling their contract and somebody has a slip and fall, it's possible that we could get some of that money back from their general liability carrier. Super important to make sure you're reviewing your policy or your contracts with your vendors to make sure that you know what those contracts are. And it may be something that the carrier is going to ask in like that snow removal situation. They may ask to see the contract. It's important to gather information when an injury happens as soon as possible. People's memories fade. You want to make sure you can retain as much evidence as possible while it's still fresh in people's minds. Also, if you have things like video footage, tend to be recorded over after certain periods of time. So you want to make sure you retain any relevant photo or video evidence before it gets destroyed. And we definitely do recommend investigating near miss situations. So maybe there was an accident, but nobody was actually injured. Still important to investigate to see why that accident happened and make sure that you're preventing future injuries as well. As far as who should conduct investigations, this is definitely something that varies widely by organization. My recommendation is always the injured worker's direct supervisor is the best person to kind of conduct that initial investigation. They're the most familiar with the employee, they're most familiar with the work processes, the work environment. So getting their take on what happened is typically the best firsthand information we can find. Some employers have safety professionals, certainly qualified to complete investigations, whether that be an internal safety person or checking with your carrier or your insurance agent about safety or risk professionals could help with investigations as well. And then some companies, this falls under the HR umbrella, and your human resources department will complete investigations. The goal of an investigation is really to determine the root cause of the injury. Root cause speaks to the specific details about what happened and what was happening leading up to the incident. And the more detail, the better. I think, answering the five standard questions of who, what, where, when, why is a good start. Want to evaluate if there were any policy violations or if progressive discipline is appropriate. And then to really address root cause of an injury, I like the ask why 5 times method to kind of get to the bottom of what happened and why. As we mentioned before, getting timely videos and photo evidence important, as well as timely witness statements. If you are getting witness statements, it's best to have them write it or type it in their own language and have them sign and date those statements to make sure they're valuable evidence for your claim investigation. All right, so when we're doing our investigation, the key here is detail, detail, detail. Give an example of a poor incident description. John fell the other day and hurt his leg. Well, why did John fall? What day was it? Which leg did he hurt? What is the actual injury? Did he scrape it? Did he, is the bone poking out? What's going on with John's leg? So in contrast, we have a better example here of at 9:03 a.m. on Wednesday, July 5th, 2023, John Doe was walking down aisle B in the North Warehouse when John stepped up on a pallet that was in his travel path. Pallet buckled, sending John's right foot through the wood, causing John to lose his balance and fall down. John's right ankle was cut by the pallet wood, and John landed on his right knee. The knee became very swollen and discolored. So this answers almost all the questions of the who, what, when, why, where. And then when we kind of take that information and get to the ask why 5 times concept, why did the injury occur? Well, John tripped on the pallet. Why did John trip on the pallet? Well, the pallet was in the aisle or his travel path. Why was it in his travel path? Well, the person who emptied the pallet didn't remove the pallet from the travel path. Well, why didn't they do that? Well, they had another pallet to unload in the next aisle. And it's like, why did they have to go to the next aisle? Well, they were short staffed due to illness or employee turnover. So in this situation, the outcome of your investigation may be that the root cause of this injury was, not having enough staff to adequately perform the work and making people rush or cut corners. And I think in any sort of insurance or risk management role, I encourage you to just be curious and ask yourself, what else am I missing? If something doesn't make sense to you, I always used to tell people in my prior role, the supervisor was taking the injury report, sending it to me. And it was my job to turn it into the carrier. It's like, if I have questions and I don't understand what happened, how am I going to, articulate and answer the questions that the insurance company has? So just the more detail, the better. And some examples of some additional details that could be useful. Was the pallet in poor repair? Is that why it buckled? What was he doing in that aisle in the first place? How fast was he walking? Was he wearing the appropriate footwear or personal protective equipment? Just kind of digging a little bit deeper and not just looking at the injury at face value. I do like to mention there are some mandatory reporting requirements outside of the work comp space. In Wisconsin, the Department of Workforce Development does require that all fatalities be notified or be reported to the DWD within 24 hours, either by call or faxing information to them. As well as OSHA. OSHA requires mandatory reporting for a death within 8 hours of the situation, and they require reporting within 24 hours anytime there is some initial inpatient hospitalization. And I like to explain that a little bit further. So if somebody injures their shoulder and they have to go back and have surgery, 2 months down the road, and they're in the hospital for the surgery, you don't have to report that to OSHA. But if the injury is so severe at the onset that they have to go to the hospital and they are kept inpatient for something beyond observation, you do have to report that to OSHA within 24 hours. Also, if there is any sort of amputation or loss of an eye, you do have to report that to OSHA as well within 24 hours. If you have questions about that, let us know. We have some wonderful risk control folks here at Houseman Group that are OSHA experts and do OSHA training. So if you're ever not sure, you can reach out to me or one of them and we'll get you the information you need. All right, coming up here on the HR and employer perspective. So I like to share kind of my best practices as far as organizational structure and who's responsible for what. Of course, this is going to vary organization by organization and you need to do what's best for your business. But from my opinion, the role of HR and management in the work comp process, varies widely by organization, but at the highest level, they are responsible for managing the insurance relationships, policy renewals, submitting claims, um, helping with payroll data, things of that nature, as well as guiding a manager or supervisor in investigation and follow-up. As I mentioned earlier, best practice is to have the direct supervisor as a primary contact with the insured worker. This kind of speaks to the culture of the organization and making the injured worker know and feel that their employer cares about them. So I think a lot of, especially in like high, really fast-paced work environments, manufacturing, things like that, the inclination is when an injury happens to just pass that person off to HR and let them deal with it. I think the outcomes tend to be significantly better when the manager stays engaged and involved and is the face of the organization. It's the person the employees most comfortable dealing with on a daily basis. So that would be my recommendation. Other HR and management roles would be coordinating benefits, whether that if there's any FMLA or Americans with Disability Act, crossover. And certainly when claims start to escalate, that is an appropriate time to move it over to the HR department to manage moving forward. If the employee has quit employment or is fired, there's no reason that supervisor needs to remain engaged. Certainly, if there's a fatality involved, HR is going to need to talk to the family and things of that nature, as well as any benefit related issues. And then once something reaches a stage of litigation, I think that's also appropriate where HR is kind of the centralized messaging arm of the organization to release information, answer questions, things of that nature. I also like to mention Maslow's hierarchy of needs here, balancing employee support with company interests. I think workers' compensation tends to have a negative stigma that, employees are out to get something for nothing and want to screw the employer over and get as much money as they can. I don't think that's the case in most situations. I think, when an injury actually happens to an employee, their first question or their first thought isn't how am I going to screw my employer out of a bunch of money. Their immediate concerns are how am I going to pay my bills? How is my family going to eat this week? And the most common thing I hear is they're worried they're going to get fired or that people are going to be mad at them for sustaining an injury. So just kind of wrapping around that injured worker, making them feel supported and that, you're going to help them navigate the process is really going to have positive outcomes on your program and your employee culture overall. That wraps up my presentation. I am certainly open to taking questions now. If you're not comfortable now, you can call or text me at the phone number here on the screen or email me at jhiller@myhouse.com. I think pause here. Cassie, is there any questions popping in the chat?
If anyone has any questions, you can throw them in Q&A. You can throw them in chat right now, and we've got some time to talk about them. We haven't had anything come through yet, but I will give this a couple seconds just to see if anyone's typing away. Yes, to answer this question here, we will share the PowerPoint. The copy of these PowerPoint slides will be sent out to you as well as a link to the recording you'll get in the email. Have an HR question. You can certainly put it in chat and we can try to answer it. Otherwise, we have some HR people within the agency who we could maybe put you in contact with. How is potential risk different than deviation?
maybe the question is positional risk. So deviation is where the person is doing something that is clearly outside of the realm of their work environment. That was kind of like the going to McDonald's on the way to work example is kind of an example of deviation, or the walking out to the parking lot to do something of a personal nature. Positional risk, I think, means that they wouldn't have sustained an injury but for the fact that they were at work. They are a little blurry. I think I see where the question is coming from. I think I gave the example of licking the soup can lid as a positional risk thing, where they wouldn't have been eating that can of soup, but for the fact that they were at work that day, or they slipped and fell in the bathroom because they were at work. Um, so the lines are a little bit blurry, but I think that the key thing in deviation is that they're doing something that is not for the benefit of the employer and that is almost exclusively personal in nature.
They did follow up asking, what about the walk on the break and they fall in the lake?
Yep. So I mean, if it's a secured campus where the general public doesn't have access to that lake, then, they wouldn't have been on that campus except for the fact that they were at work. That was where the positional risk kind of came in. I still think that one's a little bogus myself, but the state disagreed.
This is more of the HR question, Jason. So if you don't have an answer for it, I think that's fine, and we can maybe connect this person with someone who might have the answer. But they are asking if an 8-hour employee who's not salaried has to take a 30-minute unpaid lunch, and if they don't, what to do if they don't say they want to take the lunch. I'm not sure if that falls in your court at all.
Um, my official answer is I cannot give legal advice, and check with your employment attorney. But in Wisconsin, anyways, there are no mandatory break periods unless the person is under 18. So assuming the person is over 18, it really falls to your employment handbook and your policies. So if the lunch break is an optional thing, then there is no reason that they have to. But if it is something where you definitely want your employees to be taking, then you should be building it in as a mandatory policy in your handbook.
Thanks, Jason.
Yep.
They're following up asking about smoke breaks.
Again, that's going to kind of come down to what your policies are. Some employers have smoke-free campuses, things like that. I definitely would recommend having people punch out for smoke breaks, but if it's a paid break and they're staying on your campus, and I had one where the overhang that they were standing under smoking fell and hit them in the head. That was a compensable injury. They were on a paid break on the campus. The further you can get them away from their work duties, the better. But it's hard to stop those kind of creature comfort injuries.
For sure. Next question is, what is your recommendation for documenting and or reporting an incident where an injury did not occur? An example, an employee falling out of their chair during a meeting, but they didn't injure themselves.
Yeah, I would still, I mean, most companies have some sort of internal incident report beyond that first report of injury that I showed. So that is something, if you need help with that, I can give you a template to use. But or even, I mean, at a bare minimum, just give the employee a piece of paper and say, write down what happened, just so you have documentation. So 3 months down the road, they're like, gosh, my back is still hurting from when I fell out of that chair 3 months ago. You have it in their handwriting that, the left side of their back was hurting and now it's the right side. So I mean, those kinds of details you can glean from even just a basic written statement about what happened. But something is always better than nothing. But if you want something more extensive, I'm happy to provide templates and answer questions like that.
Wonderful. Can you talk about work comp reporting procedures and if you have the suspicion of a false claim of injury?
Yeah, definitely. I mean, I think if you're using like email reporting to the carrier, I would always put, any red flags that you know about when you're reporting in that email, and, ask the carrier to thoroughly investigate. I encourage you to have as many concrete, provable facts when you're raising those kinds of concerns. I see a lot of, well, we don't think this is real, or we think this is bogus, or we've heard, that they were out water skiing this weekend, or we know that they moved their apartment, or things like that, or it's kind of gut feelings and things like that. The carrier is ultimately held to what the doctor medical opinions are. So if they go to their doctor and the doctor says this is a work-related injury, and you don't have compelling evidence to dispute that, you can kind of get stuck with the claims. But that's where things like the independent medical evaluation can come in, where maybe the employee isn't telling their doctor the full story. The carrier can get all of the evidence that you provide to them to the IME doctor so that they have all of the information before they can make an opinion. And that's probably, the second line of defense. If the employee's doctor is supporting them, we can go to the IME doctor to get another opinion to make sure that it's compensable.
Great, great answer. Thanks, Jason. I'm going to post a link for everyone in chat. We are actually out of time, so if you need to leave, that is totally fine. I'm going to add it as well into the follow-up email that you all will receive. And again, that's going to have a copy of the presentation slides, a link to the recording, and you'll also be able to see the HRCI and SHRM CE credits as well. So all of that will be shared with you alongside this link. Jason mentioned the pre-employment screening workshop that we're doing. There's a lot of really great seminars that we'll be doing, and it is September 24th. We hope you can make it. And if you are a client of Houseman Group, please reach out to one of your consultants, and we would be happy to share a discount code with you as well. And thank you very much for joining us today. We hope this information was helpful for you. And Jason, again, thank you so much for sharing your knowledge with us today.
My pleasure. Have a great day, everyone.